And a new development this hour in the Stormy Daniels hush money investigation in Manhattan. Former President Trump's legal team has asked the Manhattan DA's office to call a witness in the case who can testify to the credibility of Trump's former personal attorney, Michael Cohen. Just a short time ago, former Cohen legal advisor Robert Costello confirmed to me that he will testify before the Manhattan grand jury tomorrow. Cohen is, of course, the chief witness for the prosecution, having admitted that he made hush money payments to Daniels and another former Playboy model in the days before the 2016 presidential election using campaign donations. Now, he says he did so at the request of then candidate Donald Trump, though Trump denies any affair with Daniels. Now, Cohen was imprisoned and disbarred after pleading guilty to campaign finance violations and other crimes. I want to bring in former federal prosecutor Shan Wu to talk about this. All right, Shan, so we have tomorrow another witness potentially coming before the grand jury. And this witness is supposed to speak to Michael Cohen's credibility or lack thereof. How unusual is this?
Well, it is very odd for a number of reasons. It sounds like he's going to be a surrogate for Trump testifying. In New York, they invite someone who's possibly or likely to be indicted to have a chance to make a pitch to the grand jury. Trump's apparently not going to do that, which is wise, and I guess this is the substitute. What's particularly odd about it, though, is he had at one point spoken with Cohen, and he says that he was not formally retained by him. He also told the New York Times that Cohen had waived attorney-client privilege. But it's a very dicey ethical situation. If he gave Cohen at one point any kind of confidential advice, whether or not Cohen had waived the privilege, one, he might reassert it, but two, you still, as a lawyer, can't use confidential information to do something adverse to your client. He's obviously going in to be adverse to him to try and undercut his credibility. So it's a very odd situation.
How unusual is it for prosecutors, right, because the prosecutor's running the show here, to grant a request from a defense team to bring someone in?
That's not necessarily unusual. If you're a prosecutor, if I felt something was just, way out in left field, not very relevant, I wouldn't want to muddy up the grand jury's analysis here. Here, however, it actually works to their advantage because Costello is undercutting his utility later. He's going to be locked in now. They're going to know the best he has to offer to help Trump. So it's really a poor move by Trump's team putting him. I mean, the chances of them actually derailing an indictment at this stage are very, very low, practically non-existent. So if I were them, I wouldn't even bother putting him in.
That's interesting because I was told that the DA didn't really want to resist this request for optics reasons, right? If they refused to put a defense witness on, that would become a whole thing. But ultimately, it's up to the grand jury, right? Whether they want to hear from this person. Do you think the grand jury will want to hear from Costello?
I think they will. Yeah, I think, first of all, the prosecutor has a fair amount of sway over what the grand jury is interested in hearing, and the prosecutor could tell them, look, we think this will be valuable. I don't think they'll override that.
And then Michael Cohen says he and his attorney, Lanny Davis, they're going to be at court around 1:30 tomorrow as potential rebuttal witnesses. So he'll have the chance to rebut what Costello says about him?
Yeah, that's odd, too. I don't think the prosecutors should put him in as a rebuttal witness. I mean, for one thing, to the grand jury, it looks like now there's a he said kind of situation. Second of all, I mean, unless they produce an audio or transcript, Cohen will have to listen first to that to try to rebut it, which is kind of questionable if they should even do that for him hearing another witness. So while the prosecutors probably want him on call if Costello says something that they think is really problematic, it's not the normal practice that you would have in the grand jury, this kind of witness versus witness scenario, and it's not really a good strategic thing for them to do, which brings me to my original concern that it might be a little bit too quick in terms of Bragg having decided to move from 0 to 60 on this case. The case has been worked up for years, but it's possible that with his office trying now suddenly to push it forward, haste can make waste.
Yeah, there are a lot of questions right now that we really haven't answered in our reporting about why we're seeing this uptick now. But let me ask you, if there is an indictment, and that's still an if, what kind of charges do you expect would be brought?
Most likely, they're going to start with this falsifying of business records for booking this as a legal retainer fee or something when it was really meant for Stormy Daniels and related to the campaign. That all by itself, just falsifying, is a misdemeanor under the New York laws. But if they can tie it to concealing another felony, either a New York State election law crime or perhaps trying to piggyback it onto the federal campaign violation, that bumps up the falsifying to a felony charge. Then the unknown here is if Bragg is actually revisiting the many financial crimes that were worked up, which he charged the organization with. It's theoretically possible to reopen that at this point because it would be related to this. It's a business record. That would be bad news for Trump because then he'd be looking at the tax fraud, the banking fraud, a lot more charges. Unlikely only because it seems like we haven't gotten wind of that. You would think he'd want to put in the CFO Weisselberg again if that was going to happen, but it's possible.
That is certainly a question we've had about whether Weisselberg would be asked to testify here. Shannon, lastly, just compared to all the other legal investigations that the former president is facing, I mean, how does this one stack up?
This one is probably the least threatening in terms of the jail time. It's also a little bit challenging because it's older. And Cohen, as a cooperating witness, could have some baggage. I mean, I don't think it's so much baggage that he wouldn't be effective as a witness. I think he will be. But it would have been low on the radar screen. The Georgia one is much more developed, and obviously the January 6th and Mar-a-Lago classified documents cases are massive, sprawling investigations with very serious consequences.
Yeah, and as we just reported this week, dozens of subpoenas going out to folks at Mar-a-Lago. So active and ongoing.
Absolutely.
Shannon Wood, thank you so much.
You're welcome.